Welcome to LEO Radio. My name is Jim Harris, and today we're talking about a common issue that happens throughout the country uh, dealing with neighborhoods. Now, not every neighborhood problem is going to be a problem where you would have to call the police but the one we're going to talk about today really involves HOAs, homeowners associations, communities that have their own rules and when they should enforce those rules themselves and when should they call the police. Now, with me today, I have Mike Polulak from Polulak Law. Mike, you want to introduce yourself and give us a little brief history about you?
Sure, yeah. Hello. So Mike Polulak. I'm an attorney in New Jersey, and for the past 20 years, have exclusively specialized in representing condominium, homeowner, townhome, cooperative associations all throughout the state of New Jersey, from the high rises to the 55 and older communities, the really large gated communities to your regular small condo association. And over the course of 20 years, we've had our dealings with the police in a bunch of different aspects. So we thought it'd be a good idea to kind of bring those two worlds together to try to provide a little insight on how we can probably work together, community associations and the police, to try to resolve or deal with some of the issues that come up on a daily basis.
Absolutely. Now, I'm glad you brought up the fact that we're from New Jersey. Now, as we know, New Jersey law may differ from other states, so it's very important that the law enforcement officers as well as the community organizations follow their appropriate policies, their what they have in place, as well as their state law, and for us, our own policies and procedures. So we're going to talk a lot about the generic aspects of things, but when it comes down to brass tacks, they're going to have to really make sure that what they're doing out in the field or what they're doing with their communities falls in lines with their laws.
For sure. And I should also point out, this is not legal advice, right? We're really just talking and having a conversation about a bunch of the issues that come up.
That's it. We're two guys, two schmoes having a conversation. So one of the first things we want to talk about, and I've lived in a condo community myself, so I've seen a lot of these problems, has to deal with parking issues. Now, in some associations, they have an assigned spot, maybe an assigned carport area. We're not talking specifically about a driveway, so to say, right now. We'll get into that in a minute. But somebody who has an assigned spot, and whether a neighbor or a neighbor's friend parks in that spot, where do we go with that? Is that a police matter or not a police matter?
So let's back up for a moment. So when you move into a community association, you purchase your home, and there's two sets of documents, right? You've got your bylaws that govern corporate governance for the community association, and then you have something called a master deed for a condo association, or a declaration of restrictive covenants, a declaration for townhome and single-family home communities. I'm bringing that distinction out because when we talk about parking, it matters who owns the parking space. So in a condominium association, the association in its master deed owns everything from the outside of that entire parcel of land in, except what's carved out in the individual deeds. So you have basically from the sheetrock in with a couple other things that are owned by the owner. However, there are a few condo associations that deed the parking spaces over to the owners.
Now, that's important because when I moved into my condo association, every unit had a deeded space, and my space had its own number on it and everything. So that was my space.
Right. So there's deeded spaces, and then if an owner owns their space, an association cannot tow from their space. It's their own private property that they own. With a townhome or a single-family home community, owners own from the four corners of their lot. Everything on that lot they own, including a driveway or a garage or whatever it is. The declaration states who's responsible to maintain, repair, replace certain aspects of it. Maybe the association mows the lawn, association could be responsible to replace the roof. Irrespective of that, they own everything there. So when they park on their property, again, the association cannot tow their vehicle. Most communities, however, most condominium association communities anyway, state that everything outside of their unit is common property owned by the association, some of which is limited. So a lot of assigned parking spaces are owned. That area is owned by the association, limited. It's limited common property, limited to the use of the owner who has access to it. So a lot of those parking spaces will have an assigned number to it, right? Oftentimes the owners think, hey, I own this parking space. The reality is the association owns it. They've dedicated the use to that owner, but it's owned by the association. So in those communities, the associations can actually tow from those spaces. But before they do so, run it by the lawyer, because I'll tell you, if it's a deeded space and we tow it, you're going to have to reimburse the person, give the apology tour, the whole thing.
Gotcha. So it's a very important distinction that has to be made. Before a homeowner calls the police for someone parking in their lot, they need to know, does that space belong to them through deed, or is it common property? If it's common property, they should call the association.
Correct. So if it's common property, and oftentimes the owners have no idea, right? But
Exactly. Yeah, that's why we're here.
people just don't know. You buy whatever you buy, you think it's your parking space, you own it. The reality is you probably don't. If it's a condo association, you could, but unlikely. If it's a townhome or single family home and they park on their driveway, the association does not have authority to tow. In New Jersey, in order for a condo or homeowner association to be able to tow, we have to comply with something called the Predatory Towing Prevention Act.
Correct. And a lot of states have, they might not call it that, but a lot of states have that exact same language in their state law. So what you're saying is it's very generic to New Jersey right now, but if you're listening to this from Florida or California, you have to know your specific laws, because the signage, the everything that has to be in place prior to you towing matters.
Sure. Yeah. I mean, specifically in Jersey, you need to have the 3 foot by 3 foot signs. If you live in Jersey, you've seen them. They're the white signs. They comply with the state law, and it has the Department of Community Affairs, contact information, towing information, pricing, all that stuff. So if your car gets towed, you walk to the sign and you say, well, this is who I call. This is where it's located. Get the Uber ride, go get your car. The associations also need to have a resolution in place authorizing the board to tow the vehicles. So if we don't have both of those things in place, and also a contract with the towing company, the association cannot tow vehicles from anywhere located within their community.
So association, proper signage, resolution, and the authority to call. So
Sure. So here's where a lot of times the police involvement comes in on my end, where you have a community that has a roadway going through it that's owned by the township, right? It's a municipal roadway. Association doesn't own it. Township removes the snow, fixes the potholes. The town deals with it. We don't own that property. So the question becomes, can we now, the association, enforce our parking restrictions? And in New Jersey, the answer is actually yes, for the residents in the community. So there's a New Jersey case where this was challenged, and somebody was parking a commercial vehicle in the community association, and the roadway that they parked on was owned by the township.
Okay.
Association then goes ahead and starts to fine them. I believe they ultimately towed the vehicle. The guy sues, they make it to court, they end up in the appellate division, and the court said, even though the roadway itself is not owned by the association, it's located there, and the association can still enforce its rules amongst its owners in the community.
So if that was a Joe Schmo off the street, he lived across the street, not part of the association, and he parked his car there, it's a public highway, they would not be able to enforce that particular.
You are 100% correct. So this issue actually came up a couple weeks ago at a board meeting. Similar thing. There was another adjoining association next door. The residents next door were parking on the public roadway in this community association. And the board said, we want to tow them because they're taking up all the public parking areas, right? The answer ultimately was, you cannot tow their vehicles because they're not owners, subject to your governing documents, the Declaration of Restrictive Covenants, the Master Deed, and the bylaws. So because of that, the answer was, you can't tow their vehicles, but you can tow unit owner vehicles who are not complying with your own rules.
Yeah, one of the many gray areas we talk about with this. And it goes right into my next thought of, we often get calls all the time, and it's not a police matter, it's a homeowners association matter, of when guests or even when residents are taking up all the guest parking, They have their assigned space, but they're not parking in it. They're parking in all this guest space, and they're taking up all the guest parking, and it's in front of my unit, and I want them towed, or I want them fined, or ticket them. So we get called as law enforcement, and and again, it's a gray area. We're like, well, it's a legal parking space, and they're parking in it. Do you own that space? And the answer is no. The association does. So here's another situation where they're calling the police instead of reaching out to their homeowners association to handle those issues.
Correct. Yeah. Again, think of it as just private property, right? Somebody's parking on your private property. The owner can deal with it. The police are not going to come onto the private property to enforce it. The caveat, again, being if it's a public roadway, oftentimes the township will get involved to tow vehicles if they're parked in front of a fire hydrant. If they're parking in a manner that's not appropriate under the township codes in the community, even because it's on the public roadway. Off the public roadway, police really shouldn't be involved.
All right, well, let's take it a step further because, since we're talking about public and private, now you have a situation where you have a single-family house and it has its own driveway, or even a townhome who has a garage and a driveway. Obviously, somebody parks in your driveway. It's your driveway. It's not a homeowners association. Now you're supposed to be towing that vehicle if you want it removed. It's your property.
Correct.
So in those situations, there are rules, depending on what state you're in, rules of what you need to do to call the police to have that vehicle towed. Can you tow it? Now here in New Jersey, you could call an officer. They would write the ticket for you for that illegal parking on private property. It could be a city ordinance, could be a local ordinance, it could be a state law. You have to follow that. And then there's towing procedures in place where you can personally have that vehicle removed if you follow those procedures. So what about the one thing that we get all the time in these communities is somebody's parking too close. Somebody's parking in front of my driveway. What about those situations? They're still on the road, but blocking that driveway.
Yeah, good question. So I deal with this on a daily basis, it seems like, as well.
Yeah, like this is why we're here, because it's common issues. They either call the police or they call you guys. What can we do?
So I think we first look at who owns what here, right? Who owns, first of all, the driveway? Is that a common element owned by the association? Because it's actually, let's say, a condo association. A lot of condo associations look just like townhomes. By looking at them, you couldn't tell the difference. But we look at the ownership structure. Is it a master deed? And is this all common property owned by the association? If so, it's the association that's going to have to deal with this, right? If this is a townhome or single-family home community and the roadways are owned by the township, then I think the answer is the township's going to have to get involved, call the police. If it's a single-family home or townhome community association where the roads are owned by the association, it's the association going to have to deal with it. So we start with who owns what and then kind of take it from there. The party that owns it is the one that has the right to enforce the parking restrictions.
Okay, so moving on to the last part with the parking violations is there are areas within the communities that are fire lanes, that are egress, ingress for emergency vehicles, things like that, and people are blocking in those. No parking zones. That it is an association area owned by the association, but they're parking illegally in a fire lane or in those particular areas. What is your suggestion for those areas?
If the association is not dealing with it, call the police.
Okay.
Yeah. So let me ask you about that, though. So we have some situations where people park both ways on a roadway in a way where it would make it impossible for a fire engine to get by. What would your suggestion be on that?
So in those situations, it creates a safety issue. Now, that's where we as law enforcement, if the association can handle that and we get the call, ultimately we'll take a look and we'll try and mitigate that so that we can, in the event of an emergency, ambulance, fire, and anything that has to get through there, it creates that safety issue. However, if they're not violating a law at that time, if they're properly parked, then they're properly parked. We can suggest an alternative strategy, but it comes to the point where we enforce the laws and ordinances and things like that. But if there's nothing to be enforced, it's just a suggestion, and hopefully we can mitigate it that way through the community.
Yeah, I think the real reason why this is such an issue today is most developers, at least in New Jersey, when they get their approvals to build a community, they only have to build out 1.5 parking spaces per unit. That seems to be like the general theme for most municipalities, which is insane.
Yeah,
Because nobody has 1.5 cars.
No.
Right. And most families have 2 cars. So it's inherently an issue before the place is even built out. So this just creates what we're talking about, which is like this endless issue of people not having enough parking spaces and fighting over them.
And that's not going to even change unless we change building codes and all that kind of stuff. And that's politics.
It's politics, and it's not going to change retroactively, right?
Right. So we're going to be dealing with these for parking issues for a long time. So moving on to the other traffic and roadway issues, speeding, stop signs. Nowadays, a lot of organizations, they allow the golf carts. It doesn't matter with these if it is a public road or a private association-owned roadway.
For sure. So at least, again, I'm going to have to speak in New Jersey here. So in New Jersey, there's Title 39, moving vehicle violations in the criminal code. Title 39, if an association owns its roadways, we can dedicate Title 39 authority over to the municipality so that police officers can then enforce moving violations. Under the New Jersey Condominium Act and case law, associations cannot enforce moving violations. There's the caveat, though, and there always is. Associations have to make sure that we're protecting the general public, the health, safety, welfare of the community residents, right? So if we have somebody speeding through a community, we can't say, you're going 12 and a 10, right? Because they have the cheesy 10-mile-per-hour speed limit signs around. But rather, you can say, you're creating a nuisance. You're creating a danger to the community residents. We can't allow this. We're a private community association. We're going to assess a fine against you for doing this, right? If there's Title 39 authority, we can get the police involved, and then you can ticket for speeding.
So that is the big gray area because first and foremost, the association has to grant permission for that to enforce moving violations. And obviously, DWI, for example, DWI on private property, if you're drunk, you're drunk. If you get in a crash, we can come in and we can handle the crash as well. But when we're talking about basic, stop signs, speeding, all that kind of stuff, it does matter if the association owns it and grants permission for law enforcement to come in and enforce motor vehicle law. If it doesn't, then it's on you.
Correct.
Because it's private property at that point.
Right. So I guess back to the beginning, right? Who owns what, right? So if it's owned by the association, we can enforce our nuisance or danger regulations we have in our association's governing docs. We could also grant Title 39 authority over to the township to enforce moving vehicle violations. Otherwise, if it's owned by the township, then the police would enforce moving violations.
So along with vehicular traffic, people parking in areas they're not supposed to, let's move on to that person doesn't belong in this community. I don't know you. You're suspicious to me. Or I've never seen this vehicle here. Now, when is a suspicious person actually suspicious in a community? Because sometimes they call us for, just a young kid walking through. It's not a gated community. They're just walking from point A to point B, and they happen to be on your roadway.
So I had this issue recently where a group of teenagers from an adjoining community would come over and they would fish in the pond owned by the association, right? And there's no fishing signs around it and fences. And what happens? What do? They call the police endlessly. And by the time the police get there, the kids are gone. And this game has been going on for a year.
Correct. And in these situations, the community owners who are calling the law enforcement, they're getting upset at law enforcement for they're not here fast enough. What am I paying for? So it creates a lot of community law enforcement strife between the groups. community satisfaction goes down in that area because we're not doing our job.
Right.
But in essence, it's like when we get that call, we're like, it's a kid fishing in a pond. Would you rather him spray paint your house? But either way, I digress. But let's move on to what the situation is.
Yeah. So again, you've got a private community association with its own rules, right, and governing documents that affect just the owners. The owners are all subject to it. They're all members in this association, and they have the rules. The board can make and change those rules, but it applies to them, not outsiders, right? So when an outsider comes in, it's just somebody trespassing on private property. So in the situation I'm talking about, the association, as the owner of the private property, files criminal trespassing complaints against the juveniles. And that's ultimately what ended up happening.
So in these situations, walk me through the steps of what the association should be doing prior to law enforcement actually even showing up.
Okay. So I would say step one is record, right? So we want to make sure we have a record of every time somebody's trespassing, right? If we can get any identifiable information on the kids or person coming into the community, great, and contact the police and make the record there as well. Hopefully we can get identifying information. Like I had another situation come up a little while ago where somebody was coming into, this happens all the time. The association's got the big garbage dumpsters, and you get people from outside the community coming in and dumping all their stuff, and the association pays for it. It's really expensive to remove all that stuff. So what do? They set up like trail cams, and they record, and now we get the guy's contact information. We get their license plate, go to the police, file the report, and ultimately, in that case, you got private owner, the association versus private owner who caused financial damages to the association because they were charged a whole bunch of money. The guy was throwing out tires and everything else. So then we sued him. They're not subject to our governing docs, but when somebody causes financial harm to you as a private individual or private corporation, you can sue them. So we went after them and ended up collecting all the additional charges paid for by the association because they were dumping on our property. So private owner, private owner community association to private owner outsider coming in.
You're bringing up a great point because we've been called on this before, the illegal dumping calls. So in this case, the situation is that where the dumping took place, the association should contact their attorney to file these civil.
Yeah, so this was done civilly, but first we have to find out who the person is, right? So one, try to investigate, find if you can figure it out. Two, contact the police if we have some identifiable information, file a police report, and then we can get the person's contact information and pursue them for any damages that they caused.
Okay, but this is not a 911 emergency.
Doesn't sound like it.
You are not dialing 911 for this to say somebody illegally dumped.
Right.
Okay, so this is something that you would just, do all your record keeping, contact the police on a non-emergency line, and then the police can do a report. And some jurisdictions, you even have online reporting now. You don't even need an officer to come out to you to report something like this. You can do it online for associations. So, so not an emergency. So with the trespassing, the unauthorized use of common areas, we often get, myself, I actually, in my association that I'm down in Florida, I belong to, we are tied to an association right next door. We share common gates, we share roadways and everything like that. And they sent out a thing: do not use our pools, don't use our tennis courts. You're not members of our association. So we do get from time to time calls to the law enforcement about, hey, this person doesn't belong. They're in that association over there. They're using our pool. How do we go about using or addressing that?
So first, similar to the dumping issue, right, or the trespasser, it's a private community association. The private landowner has a trespasser coming in, somebody that's unauthorized, right? So what do? We kick them out if we can. If they refuse to leave, my answer, sorry, is call the police.
Well, no, you don't have to be sorry. I mean, you're taking steps to do it. You ask them to leave, they've refused to leave. Now it absolutely is a trespass issue, because sometimes, to be honest, when I was new to the community, we shared common gates and everything. I thought I was allowed to use their pool. I thought they were allowed to use our pool. We're in one big community surrounded by one huge gate, and we have common roads and everything. So I was unaware, but no one ever told me. So you should have that aspect of, you're not supposed to be here. You can't be using this. You have to leave. You have to give them a warning. Even if law enforcement comes, our job is to give them the warning, document the warning that they've been warned that they're trespassing. Then if they come back, now they're defying on that trespass, and then we can take that enforcement action. Or if they say, no, I ain't leaving, then again, defiant. So having that aspect of being able to say, I'm sorry, who are you? You're not supposed to be here. You need to leave. That's important.
This also comes up a lot with the resident there. He's the drunk guy at the pool, right? It's the guy that brings in the beers when they're not allowed to, and they're drinking all day, and now they're causing an issue. I mean, this comes up every summer, right? All over the state. So we deal with this all the time. And what does the association do? Well, now he's a member in our community association subject to our restrictions, right? So we then, the association, we can now send a demand letter to them. We can remove access to amenities usually for 30 days, assess fines against them, tell them to leave. If they don't leave, again, now we contact police if they're not willing to remove themselves. So this pretty common theme, I'd say,
Yeah.
starting in about 2 or 3 weeks.
Yeah, here at the Jersey Shore, absolutely. Now, who actually has the authority to tell that person they're not supposed to be there?
So usually it's a lifeguard sitting there who's probably a 16 or 17-year-old kid.
Yeah, probably.
Right? And then you have a gate attendant checking people when they come in. So ultimately, it's going to be one of those two people. So I always say, even though the lifeguard's a kid, they're the authority figure. They're not always a kid, but usually they are.
Yeah. No, I hear you.
It's the authority figure. If the lifeguard tells people to get out of the pool for one reason or another, they need to get out of the pool. If they need to leave the area because they're visibly intoxicated or they're not supposed to be there, they need to remove themselves from the situation.
So what about situations where, down in my community, they've done away with the gate guards. Now it's all electronic. They've done away. There are no lifeguards. It's signage that says the pool's open from this point to this point, swim at your own risk, no lifeguard on duty. And who has the authority in that point?
So somebody on behalf of the association, if they're there. Oftentimes they're not, right? I usually find out about it on Monday or Tuesday after the weekend when I get the video or the screenshot of somebody visibly drunk or urinating or something like that. And then the association takes action. Again, we fine them, remove access to amenities, et cetera. If somebody on behalf of the association is there or on behalf of the management company that's available, the answer is they tell the person to leave. If they don't, call the police.
All right. So that not some Karen that happens to be there who doesn't like a young kid swimming in the pool, because that is a very common, does that kid have a swim diaper on? You hear this all the time, right? Mm-hmm. They don't have the authority to tell you to leave, but that Karen can call an association member. The association member can come in and say, I'm here on behalf of the association, and what you're doing is inappropriate to our rules and regulations, or we're going to ask you to leave.
Yeah, 100% correct. Yep.
Okay. All right. So that brings us to the pool and hot tub. And one of the most common issues we see is, why are they swimming after sunset? In this case, it would be very similar.
Yeah. So this pertains to hot tubs and pools and clubhouses and whether or not the association allows alcohol at events or not. It's all just weighing risk, right? It's like people move into a community expecting to be able to do stuff, to live their life, to be happy, right?
Yeah.
And it's the pool and the hot tub and everything else. And then you have the question of liability. Well, the more you make all this stuff accessible to people, the more liability there is inherently going to be. It just is what it is.
Right.
So it's a balancing act, right? The board makes the decisions on these. And is it open after the sun goes down? I don't know. If the board says that we're going to set our rules to have it open, we notify the insurance carrier and they give you the thumbs up, then it's up to the association. If you want to do that for the residents, knock yourself out.
And so I had this issue down in a condo community I belong to in Florida, where they were like, the pool is open sunset, sunrise to sunset. We got there right off the plane, hit to the pool, sunsets, and we were still in the pool, and people were, mad, upset. And it wasn't even me; it was my friends They're talking about it, and they actually called 911. Somebody swimming in the pool after dark.
Right.
Yeah, that's not a 911 call.
Not a 911 call. And by the way, that's not the police's job to enforce private rules. Again, you're not violating a municipal code, right? It's not like the law says the pool must be closed at XYZ time. No, it's just this is the private rule that the board came up with, or maybe it's in the governing documents, and that's it. So it's the association's responsibility to enforce that.
Correct. Now down there, it was the Board of Health has standards for sunrise to sunset, but I'm like, okay, we're in Florida. You're telling me all the pools in Disney that have kids swimming in them, they're sunrise to sunset? No. It depends on can you, and that's where the association can come into play. Like you were saying, can they adjust those rules? They can. They just need to tell the Board of Health, we're going to do this, this, or this. They talk to their insurance carriers, and they can do all that. But some of them just choose not to.
Sure.
But it creates a lot of issues with, the residents, because exactly what you said, you're in that community to enjoy
Living.
I don't know. And I'm swimming in the pool. I want a cocktail.
Yeah.
I understand the glass aspect of it, but when I have
You're in Florida swimming in a pool, you were expected to have a cocktail in your hand at all times.
Yeah, I think if you don't, you're kind of weird. I'm just going to say that. Yeah. So moving on into, like I said, the kids and the juveniles with the pools, kids, juveniles, they have a lot of, especially this time of year, they're grouping up. They're seeing people that they haven't seen since for months, because it's summertime or whatever it may be. Could be a holiday, whatever. But they're seeing each other and friends, and they're walking in groups. People are afraid of kids in groups. Don't get me wrong. There's plenty of kids that they do stupid things when they're in groups, but in these situations, what are the rules? What should associations do simply because there's packs of kids?
I don't know, right? That's I don't know the answer to that one, honestly. Like, you can't prohibit kids from hanging out, right? So I don't think associations should do this. We get this all the time where they're hanging outside at the clubhouse, for example. I have a community that installed something called the Mosquito, which is this craziest thing. Listen to this. It's a speaker that emits a really high-pitched noise that only juveniles can hear. So, like, as you get older, your hearing kind of goes down a little bit, and it's a pitch that once you turn like 18 or 19, you can't really hear it.
Really?
Yep. So, but when you can hear it, it's like, and ringing in your ear, you can't get to go away. So this was a community in a pretty rough area, and they had a bunch of juvenile delinquents hanging out there doing all sorts of sketchy stuff, and they installed it, and nobody hangs there because it's like this loud ear ringing nonsense in your head. So, I mean, they could do that, but that seems pretty aggressive. I want to do that for a pool or anything.
I know, right?
Yeah.
So what about curfews?
Yeah.
Our curfews are because it's a big controversy right now throughout the United States, especially even here in New Jersey, about like the curfews. Like, people are putting up curfews simply because of packs of kids and the safety of the community. So what is the stance for homeowners associations for curfews?
So I had this issue come up at a community in New Jersey and South Jersey. It was a pretty rough area, and it's a large community. So they had a gang issue. The board went to the township and said, hey, listen, we want to have the municipality impose a specific curfew in our community because of the gang issue. And they did. They passed an ordinance, a township ordinance that was enforceable by the police, that after a certain time at night, whatever it was, 10 or 11 at night, there was a curfew, like a real curfew. And it seemed to have worked fairly well, I'd say. That was my only experience with it. I don't believe a community association could enforce a curfew if there wasn't one in that municipality already. So there's a lot of like noise limitations and noise curfews, whatever you want to call it. But after 11 o'clock at night, you can't blast music, right, until 6 a.m. or so. Governing documents and association rules, they can definitely mirror that. Once we try to start imposing something like a curfew, I think it would become I've never seen a case on it. I've never dealt with it in 20 years, other than that one situation where the town was involved. I don't know whether that would be enforceable, honestly.
And even if somebody does pass an ordinance, or in your situation passes that rule, and they start enforcing it, it could always be, through courts.
You could challenge it.
It could be challenged, and that's usually where a lot of what we're talking about actually does come out, through the courts. Like what happens, rules being enforced, and they're challenged, and we find out how to actually go about doing what we do through court challenges.
Yeah, so let me just make a little side note. When I keep saying rules, really what should happen is the board should come up with some kind of policy that they want to implement, right? They should have a policy resolution prepared by the association's attorney, come to an open board meeting, they talk about it, they pass it at the open board meeting, and then we record it in the county clerk's office. And then it's disseminated to the community. And what this does is it puts all owners and future owners in that community on notice of what this particular rule is. So when they buy into the community in 5 years, they get a copy of their deed at closing, they get all the governing documents, and then they get all of the policy resolutions that have been passed by the boards. So it just puts everybody on notice. So when I refer to them as rules right now, but really they're resolutions, they're policies implemented by the boards.
And we're talking about a lot of different things, but we moved on to noise. Might as well hit that since we're here. Loud music, barking dogs, construction noise, especially, people coming in during the prime of the season. They don't like to hear construction noise when they're there. Short-term lease issues with they don't like the neighbors because they're a little bit louder. When is it an HOA issue? When is it a law enforcement issue?
Yeah, so this became a huge issue around like 2021, 2022. Everybody's home for COVID. Now a lot of people are working at home, right? So what happens? They're in a high rise and their neighbor upstairs is going to do construction for a new kitchen during the day. That's pretty normal. But the person's working right below. So when does police get involved in something like that? The answer is probably never, unless it's the middle of the night, right? Again, I would go back to pretty much all towns have a municipal standard for whatever quiet time, whatever you want to call it, from usually around 11 till 6 a.m. And if it's during business hours, if it's outside of that time frame, then the answer is call the association's management company. Maybe what they're doing is not reasonable. Maybe it is. I don't know. But if it's unreasonable and violates the governing docs, then the answer is the association should send a violation notice to them and assess a fine against them.
Or how about this? Hey, neighbor.
Oh, well, don't be ridiculous, Jimmy.
Wait, you mean I can't talk to my neighbor about...
Don't be ridiculous.
Wait, you mean I actually have to know my neighbor?
Yeah, right. So that would be ideal, right? But I'm presuming that they're not willing to talk to each other because in my world, we get involved where, they're not best of friends, the neighbors, let's put it that way.
Yeah, I don't know why they move into communities if they're not going to be neighborly. You're in a tight group area, you have to know your neighbors, or at least like neighbors. If not, go buy a farm.
Jimmy, there is a certain percentage of people that should live in a single family home in the woods alone, and they choose to live in high density housing. It's endless.
It is. All right. Well, I just want to bring this to a close. I want to thank you for having us today and meet with me. And we're definitely going to follow up because there's a lot more topics that we're going to be touching upon in our next episode. If they have any questions for you, is there a way they can contact you or anything?
Yeah, of course. So I have a website, Polulak Law, Polulak Law. That's the name of the law firm. And again, it's a boutique firm. All we do is represent condo, homeowner, some cooperatives, and townhome associations throughout the state.
All right. And if you're a law enforcement and you're looking to follow up, or you have questions, or maybe there's something that you want us to cover in the next episode of this, reach out to us at jharristraining.com. Thank you, and we'll see you next time.
Thank you.